Are you confused about whether you need a will or a trust? Do you want to avoid the time and expense of probate, protect your spouse and children from losing their inheritance, or prevent your life savings from being lost to pay nursing home bills? I'm attorney Banks Ladd of the Ladd Firm. This presentation will prepare you for your upcoming free estate planning telephone consultation. If you have not already done so, please call 251-431-6014 to schedule your free telephone consultation. Without a will, probate court will require your family to spend thousands of dollars on surety bonds, public notices, accounting fees, hearings to sell property, hearings to sell cars, guardian ad litem, quiet title actions, and other unnecessary legal fees. There are many time-consuming legal requirements for probating an estate without a will that can cost your family thousands of dollars. Having a will ensures that your intended heirs receive their inheritance. Without a will, the government may give your stuff to people you wouldn't choose, don't like, or don't even know. Not having a will can cost your family everything. Without a will, heirs will receive their inheritance upon reaching the age of majority, which is 18 in most states. Grandchildren frequently inherit at 18 when adult children predecease their elderly parents. A financial advisor recently told me about a client who inherited several $1,000,000 in his late teens. He told him that he could either live like a king for 3 years or live like a prince for the rest of his life. Over the following 3 years, the newly crowned king called him for money to buy boats, cars, and go on lavish vacations. By the end of 3 years, the young king's money was gone, and the opportunity to live like a prince was over. All of our plans include immaturity protection that prevents heirs from receiving their inheritance until they reach a specific age chosen by you. Internet and other do-it-yourself wills are frequently thrown out of probate court for technical errors, and those that aren't thrown out can cost thousands of dollars in additional legal fees because they don't comply with all of the probate laws. Therefore, a free or cheap will can cost your family thousands of dollars, making it much more expensive than a professionally drafted will. A well-drafted Alabama-compliant will is very easy to probate and should avoid the need for any court hearings, saving your family thousands on legal bills. A properly drafted will should cost your family about $1,500 to probate, but a poorly drafted non-compliant will could cost your family $10,000 or more. Therefore, spending a little extra now will save your family thousands later. There are many reasons to draft a new will, even if your old will is still valid. For example, if the witnesses to your will cannot be found or refuse to appear in court to testify that your will was properly executed, the court may refuse to admit your will to probate. Therefore, if your will is over 10 years old, was drafted in another state, was witnessed by people you cannot locate, names executors who are now deceased, includes the name of a former spouse, or doesn't include the names of new heirs, we recommend that you get a new will. Everyone needs either a will or a trust. If you want your estate to avoid probate or need asset protection for your family or yourself, you need a trust. We will now help you decide whether you need a trust by discussing the most common problems they can solve. Do you want your estate to avoid probate? Avoiding probate will prevent your children from fighting in court, stop the whole world from knowing how much your spouse and children will inherit, allow your estate to be settled much faster, save money on probate expenses, and avoid additional probate proceedings in other states where you own real property. If your children don't get along, the probate of your estate could be the last time they ever speak. Creating a trust will prevent family fighting and save your family thousands of dollars in legal bills. Distributions to family members are confidential, preventing children from knowing what their siblings received, and disinherited heirs will not be given the opportunity to contest your wishes in court. Probate court will publish your spouse and children's inheritance for the whole world to see. Elderly widows and children receiving large inheritances are commonly targeted by con artists and unscrupulous businesses who will sell them worthless investments and overcharge them for unneeded services. Creating a trust will prevent others from peeking into your family's financial affairs. Probate costs money. Your family can expect to pay several $1,000s probating your will. Since trusts avoid probate, a trust can save your family thousands of dollars in legal fees and other probate costs. Without a trust, your out-of-state vacation home, hunting camp, family farm, and other real estate will require additional probate proceedings in each state where you own such property. Each proceeding will cost several $1,000s. Conveying your property into a trust will avoid the time and expense of each additional probate proceeding. Trusts also protect assets. According to a recent Ohio State study, 1 in 3 heirs will lose all of their inheritance within 2 years due to reckless spending and poor investing. Creating a trust will prevent the unnecessary loss of assets by your heirs. Making outright bequests to children with financial problems is often throwing money in the trash. There are over 100 million pending lawsuits in the United States, with 40 million new ones filed every year. The vast majority are filed by debt collectors against individuals to collect outstanding credit card, medical, student loan, tax, and other debts. Most judgments last 20 years, and many debts, such as student loans, never go away. Debt collectors will often garnish money from an estate before children ever receive their inheritance. Children's financial protection will ensure that your money helps send your grandchildren to college instead of being paid to a debt collector. Giving money to children with addictions is a recipe for disaster. It will feed their addictions until all of your money is gone. We have seen people with minor issues become full-blown alcoholics, drug addicts, and compulsive gamblers. They will often lose their jobs and spouses as they drift into the world of addiction with your money. If you have a child or other heir with an addiction, including children's addiction protection in your plan will ensure that your money does not fuel their addictions. Do you want to prevent your children from losing their inheritance in a divorce? How about making sure your grandchildren receive your assets when your children die? Children's divorce protection will prevent your children from losing their inheritance to divorce and ensure that your grandchildren receive your assets when a child predeceases their spouse. You can structure children's divorce protection to allow your children to have complete control of their inheritance without exposing it to loss in divorce or probate proceedings. Does your spouse have the skills and experience to manage your family's assets when you are gone? If your spouse is not capable of managing money, suffers from dementia, or is easily taken advantage of, spousal financial protection will prevent your spouse from losing his or her inheritance and protect assets for future generations. Blended families have a unique problem. Spouses with separate sets of children often sign identical wills, leaving everything they own to each other and then to their children equally. Having signed identical wills, they are confident that their children will eventually end up with their inheritance if their spouse outlives them. However, within a few years after the first spouse dies, the surviving spouse often changes his or her will, leaving everything to his or her children. If you're in a blended family and want to ensure that your children receive your assets when your spouse dies, you need blended family protection. You and your spouse may have identical wills leaving everything to each other and then to your children. However, if you die first and your spouse remarries, he or she could execute a new will leaving everything to the new spouse, lose everything in a divorce to the new spouse, spend everything on the new spouse's nursing home bills, or be required by law to leave your money to the new spouse upon his or her death. Including remarriage protection in your estate plan will ensure that your children receive their inheritance if your spouse remarries. Will your family receive substantial life insurance benefits when you die? Are your spouse and children capable of managing those benefits? Most life insurance benefits are spent within 1 year. What's the point in buying life insurance if benefits are likely to be lost so quickly? Life insurance protection will prevent the rapid loss of your benefits. If you have disabled heirs receiving Medicaid or other needs-based government benefits, they could become disqualified by an inheritance. They will then have to spend all of their inheritance on their care before reapplying. Government benefits protection will allow disabled heirs to receive their inheritance without losing benefits. If you have more than $200,000 in retirement assets and need asset protection for your spouse or children, you also need retirement asset protection. Retirement asset protection will protect your assets from being lost by your spouse and children. It will also help maximize growth, minimize taxes, and avoid IRS penalties. Do you want to lose your home, vacation property, retirement income, and children's inheritance to nursing home bills? The average cost of a private nursing home room in the United States is over $100,000 per year. Medicare does not pay, causing 70% of nursing home patients and their spouses to become impoverished within 1 year, and Medicaid will only pay once you have become impoverished. Fortunately, we have a long-term care protection trust that will allow you to qualify for Medicaid without giving up your assets. However, there are waiting periods between the time assets go into the trust and the time you apply for Medicaid. Therefore, the sooner you start planning, the more you can protect. You can either fund your trust during life or after death. However, probate avoidance and long-term care protection require you to fund your trust during your life, which will take additional time and money. If you are only concerned about asset protection, you can fund your trusts at death by naming them as the death beneficiaries of your financial accounts and life insurance policies, and instructing your executor to transfer real estate and other probate assets into your trust during probate. We can advise and assist you with funding your trusts. We offer a complete set of specialty trusts that were not discussed in this presentation. Therefore, if you have a concern that was not discussed, please tell us about it in your free telephone consultation. Standard asset distribution is giving everything to your spouse and then to your children in equal shares and is free with your plan. However, you can leave your assets in some other manner for a small additional charge. Without an incapacity plan, thousands of dollars could be spent fighting in court over who makes financial and healthcare decisions for you when you are incapacitated. Incapacity plans include a financial power of attorney, a healthcare power of attorney, and a living will. These documents designate trusted loved ones to make financial and healthcare decisions according to your wishes. We can help you decide who to appoint and when these powers can be invoked. We can meet with you in person or by Zoom to design your plan. We can also Zoom in family members who live far away. Zoom is a great way to save time and money on travel for those who cannot attend in person. You can execute your plan at our office, or one of our mobile notaries can deliver the documents to your home, office, or hospital room for execution. We make executing documents easy and convenient. Our plans are the most competitively priced in the market. Will plans start at $500, trust plans start at $2,000, and incapacity plans are $250. We will discuss pricing during your free telephone consultation. Thank you for watching Estate Planning with Wills and Trusts. During your free telephone consultation, we will answer your questions about whether you need a will or a trust, what types of asset protection your family needs, and whether you need an incapacity plan. We will also provide you with a free price quote. We will call you at the scheduled time. If you have not already done so, please call 251-431-6014 to schedule your free telephone consultation.